Okay, good morning, everyone, and welcome to another Tech Tribe Community Masterclass. My name is Tarisiro, and I will be your host this morning. I'm very excited about July and August because we're talking about intellectual property, and this theme over these 2 months is hosted by Von Seidels, one of the SA Innovation Summit's partners, and they are our IP partner. And who is Von Seidels? They're an intellectual property law firm, so they are the experts, and they specialize in patents, trademarks, copyrights, designs, trade secrets, licensing, and anything else that's related to IP across the continent. And many people ask, what is IP? When you've invented something, you've got your invention. What do you do? How do you make that decision to protect it? To protect your intellectual property. And I'm excited this morning. I've got Christine, who's an experienced trademark and copyright attorney and partner at Von Seidels, and she is going to give us a deep dive. Well, we're going to do a deep dive into the different forms of IP and how they relate to our business. And IP is an asset in any business. So she's going to give us an overview and an understanding of the different IP vehicles that are available and how we can apply them to our business. But before we start, I'd like to welcome you all. Please let us know who you are, where you're joining us from in the chat. Tell us your name, what you do, what is your business, where you're joining us from, just so we know who's here with us. And Christine as well has an understanding of who's joining us here today. So I know we've got Nick here, and he says IP stands for Internet Protocol. Christine, I'm not sure if that is correct.
It does, amongst many things.
Yes. Yes. Is there anyone else? Please feel free to introduce yourselves. Pop it into the chat. My name is Tarisiro. I'll start there. I am project manager at the SACE and program manager as well in the Tech Tribe community. Anyone else? Well, when you're feeling warm and cozy and comfortable enough, please do introduce yourselves. So let me tell you a bit more about Christine. Her field of expertise includes complex trademark searches and the prosecution and enforcement of trademarks in Africa. She also counsels local and multinational companies on legal aspects surrounding trademarks and branding, domain names, and other forms of IP. She completed a dual degree in accounting and law and also holds a master's degree in intellectual property law and focused her studies on electronic IP, internet matters, and the valuation of new media ventures. Since joining Von Seidels, she was recognized as the Mail and Guardian's list of top 200 young South Africans, as one of 20 individuals listed in the business and law category, and named as one of only 9 Africans in Managing Intellectual Property magazine's list of top 250 women in IP, having been listed on annually on the IP Stars list since 2014. So that is, what are we on, 7 years? So that is incredible. So obviously we have got the guru of IP here, so we're very fortunate. And I just want to welcome you. Thank you, Christine, again for joining us this morning. And I will hand over to you to tell us more about IP.
Thanks, Tari. Just before we start, I just want to add to Nick's comment and so how important it is to get your acronyms straight. My younger sister lives in the US, and her husband has a stud farm, and we were once having a conversation about AI and AI this and AI, and probably 20 minutes in, we realized I'm talking about artificial intelligence and she's talking about artificial insemination, and we weren't even connecting with each other. We were talking about completely different things. So with that in mind, I'm going to share my screen and get us started. Right, I have to ask, is everyone seeing our little animation? Oh.
We see your screen. Yes, it's going.
Great stuff. Well, as Tari said, I obviously work in intellectual property, but it is also my absolute favorite thing. So for me to be given an hour to speak to people about my favorite thing in the world is just a treat. And I'm really grateful to all of you for joining and being here to share and learn with all of us. My aim with this masterclass is really to give you a broad overview of all the different forms of IP, how they exist, how they complement each other. We won't be going into too much detail. There's a separate IP primer already posted by the Innovation Summit. So if you want some details about something specific, I suggest you just ask Tari for that link and maybe run through that presentation. Today, I'm rather interested in convincing you that not every type of IP may be applicable to your business, but that at least some types of IP are relevant to all businesses. I'll also touch on how IP policies impact you in significant ways in your everyday life. And as we go, please feel free to post comments and questions in the sidebar, because we'll take some time and get to those as well. Now, as a masterclass on intellectual property, the obvious thing to ask is, what is it? You all know that it's intangible things. It's a protection granted for any creation of the mind. And unsurprisingly, in the information age, it's become the most valuable business asset to some of the most valuable companies in the world. And what we found recently is that those were the companies that really thrived through the pandemic and were found to be loot-proof recently, because IP is not something that you can just go ahead and destroy. So the only misperception that we encounter sometimes is that people say, oh, IP is so expensive. It's just for big tech unicorns. It is not. It is particularly important for startups, and investing the time to develop an IP strategy, creating an IP portfolio, and conducting an IP risk assessment can really influence your funding opportunities and exit, and often even the survival of your business. So when you think of IP, this is kind of the image that comes to mind as this very tech thing that became really popular in the 90s when the internet started becoming popularized. But it really has its origins more in this scene. Now, this is ancient Greek bread makers. And as early as the 6th century BCE, or 600 years BC, they were granted a 1-year exclusivity to manufacture their unique bread creation. And this is almost exactly the modern concept of a patent, which is essentially a contract that you make with the state to give you a monopoly over an idea you've had or a new way of doing things. And in return for being able to exploit that right for 20 years, you then agree with them that you'll place the idea on a public record, and after 20 years, it will fall to the public domain. So the thinking is that you're encouraging people to invest in research and design and to make back that investment, but to then share it freely with society so that others can use and improve it as well. Now, it's important to note that some things are not patentable. And there's a list here. I'd like to highlight on that list pure business methods, ways of presenting information, software that doesn't have any specific application or real life improvement. And sometimes you can even have exclusions for special cases, like currently there's a suspension on vaccine patents, and that's to ensure that vaccines are freely available for people to reverse engineer, improve, distribute, and really fight the COVID-19 pandemic. Now, modern times, this is the kind of patent that you'll see. This is one for the Google Smart Home, or otherwise known as an operating system for a home policy manager. And it looks quite complicated to explain that in a spec. But there are also more simpler patents. This is the iconic Lego block, and the other item that I'm sure you're all familiar with. Patents can also be a little bit bizarre. So here is a patent for chicken spectacles and a very impractical protective sporting vests, which I'm not sure if that really succeeded to market ever. You're more likely nowadays, as I said, to see patents that look like this. So this is the smart TV that is operated by gestures. This is a patented method for identifying different kinds of influencers on social media. So you can see a patent can really relate to anything from a tube of toothpaste right to ways of optimizing social media influence. It's really a powerful tool if you can get that in your IP toolbox. They can be costly, however, and even though there are quite a few reasons why you might invest in a patent, some that I've listed here, it may not be a very appropriate form of IP protection for a startup or a business in a particular type of industry. But having said that, if you think you've got a new idea that is also quite inventive and you want to check if something like that already exists, you can do so for free by going onto the CIPC free patent search tool. Or if you're interested in international technologies, you can just enter a keyword search on Google Patent. Now, a form of IP that is arguably more of interest to a startup is copyright. And the reason is that it is extremely valuable, but you also get it for free. Now, it applies to software and databases and all sorts of things that are very common features of modern businesses and startups. And in some countries, you can register it, but you're not required to. So importantly, if there's a copyright symbol on something, that doesn't create copyright. It merely states that there is someone claiming ownership of that copyright work. Also note that because it's intangible, you have to assign it in writing, and that piece of writing must be signed in ink or with an actual signature, not a DocuSign or anything. It's one of those items that actually require a specific signature, and that's how you transfer ownership, unless, of course, someone's inheriting copyright or you perhaps work for someone and by virtue of your full-time employment, the copyright you create belongs to that company the minute it's created. Now, monopolies on copyright, they were given by the state as early as the 16th century, but it was really when this thing was invented that copyright came into its own. So this is the Gutenberg printing press. And suddenly, when people were able to mass produce Bibles and political texts or propaganda, it gave a reason to the state and the church to want to control the distribution of those works. So this led to the very first law on copyright. We call it by the name, the Statute of Anne, because it was in the time of Queen Anne, I suppose. Its full name is quite untweetable, but I'm going to read it to you. It's an act for the encouragement of learning by vesting the copies of printed books in the authors or purchasers of such copies during the times therein mentioned. Okay, so it's quite a mouthful, but the truth be told, the aim wasn't really to encourage learning at all. As I said, it was rather to give the church and the state a way of preventing the reproduction and distribution of heresy and propaganda, and to control the circulation of ideas and information. I'll leave you with that thought for now. Increasingly, countries started to adopt similar laws, but only in 1790 did the US have a federal copyright law, and only 100 years after that was there sort of an international agreement on what the basic requirements are and the minimum protections for copyright works. Now, this was called the Berne Convention, and you might be surprised that most countries in the world still abide by this convention today, despite the evolution of technology, as you'll see later. Now, it was this printing press, it was the first of many new technologies that created improvements that called for new IP laws and new ways of thinking about how we acknowledge and protect and really commercialize or benefit from intangible ideas or industrial rights. And that's another aspect to note about IP. As new technologies develop, so do new forms of thinking, new forms of intellectual property, and it's an area of law that's continually changing. So you can't just get stuck with one act. It will always be updating or be interpreted in a new and a fresh way. So I was thinking about this, and I sent a text message to a colleague of mine, Ralph. Ralph is actually doing a workshop or masterclass next month, if you want to join it. But I vaguely remember him telling me the story about how infringers of today become the copyright owners of tomorrow. And he's currently in the US, but he sent me this very eloquent voice note, which I'm actually going to play for you. Keep in mind, I did not ask him to actually give me a lecture on IP. I just asked him to remind me what the link was, and this was his explanation.
Hey, Christine, I hope things are going well. I'm in Minneapolis at the moment visiting a couple of firms. So, yeah, having a good time here. So that comes from an article called Copyright Communications Policy by Timothy Wu. You can find that article on SSRN, but basically the story is that today's copyright infringers may well be tomorrow's copyright owners. And the way it flipped back and forth was that the original publishers of sheet music complained about the mechanical piano, because you would buy these rolls that had little holes in them and it would cause the piano to play itself, and they didn't pay a royalty to the sheet music publishers. That was eventually settled, and the idea of a mechanical royalty was invented. And then the publishers of the sheet music became the same companies that started complaining about they evolved into the record industry. And then a technology called radio came along, and people started playing songs on radio without paying royalties. And then it was the publishers of, which now were not paper rolls with holes in them, but actual, long play records, gramophones, that were complaining about the broadcasting of the gramophone record recordings. And then fast forward a couple more years, and you now have the broadcasters in the form of the TV broadcasters, who are the copyright owners of TV broadcasts, and the copyright infringer of the day is the Sony Betamax, which was the original tape recorder, video VCR, video cassette recorder. And they, of course, were complaining that by allowing people to record their broadcasts, they were librarying and therefore should be found liable for copyright infringement. So it just kind of is, to me, a fun story about how, an industry that is a copyright infringement industry may well, or seen as such, may well be tomorrow's copyright owners. Hope that helps, Christine. Keep well. Bye.
How's that? I just asked him one question and he, off the top of his head, gave me an eloquent summary of an academic article. Some people are just amazing. So if you want to listen to Ralph and his musings on IP, follow the Tech Tribe Communities posts and just see when that's up next month. But I've added a few blocks here: internet file sharing, user-generated content, streaming, and as we will talk about later, NFTs and new forms of sharing content. We're continuously evolving, where artists and scientists and the public are using content in new ways and then bringing us to a point where we have to reassess what is lawful use and what isn't, and do we actually have laws and sensible rules that address those uses. But for now, if you do have something that you think is of value, maybe it's a logo, a design, a book, script, a movie, even an invention that you don't want to disclose yet, but you want to have proof that at a particular point in time, you were the first person to actually come up with that idea or write that work. Instead of emailing it to yourself, you can now go on to Whiteboard Proof, and for about 20 Swiss francs, you can get a date and time stamped digital fingerprint of your file, and that will prove its existence at a specific point in time. So this can be very useful for enforcement reasons or licensing. You will actually get a certificate for that, and it really gives you all of these benefits. So it's something that I can encourage you to consider. If you are ready to disclose your design, however, there is a thing called a registered design. You have to register it. It doesn't happen automatically, but this is typically for things with a function. And for 10 or 15 years, depending on what kind it is, you will get to stop other people from reproducing a design that looks the same as yours. So the material can be inferior or can have different parts on the inside, but it's all about the look and the appearance on the outside. Now, it's a relative form of protection. So what that means is if the picture to the left is what already exists in the industry, let's call it the prior art, and you register a design for the middle, like the middle flag, if someone came over and made a new design, like the third option, the question would be, is it closer to your design, or is it further removed from your design than your design was from the prior art? So even that's a mouthful to explain. If you look at the image, it's kind of like describing an elephant. You see it and it's obvious. So I think in this case, we can all agree that the third option is definitely an infringement of the registered design. You can also apply designs to more modern features. So here we have Apple's swipe right to unlock feature. And you can read below there that Samsung had to pay $120 million in damages for launching a similar looking feature. So that's important. The underlying tech was not similar. It merely looks the same. And that was the quantum of the damages that they claimed and were successful in obtaining. To the right is the iPhone text bubble. And that's the reason other phones don't have that little curve on their speech bubbles. More applicable to us would be your user interface or your screen layout. So here are some more examples. We've got Microsoft's screen layout, Twitter's drifting emojis, Tinder's swipe screen, the Netflix menu, and also Airbnb's booking page. All unique designs that are different from what came before and can be held up against people who imitate them afterwards. If you want to search for designs that have been registered, you can go onto a free database called Design View, and you can also fill in a class, a keyword, Designs are registered in classes of goods. So if you want to see where your product falls, then this is also a useful way of discerning that. But I appreciate not all businesses need patents or designs, but all businesses have a brand. And for that, we need to